The Seventh Amendment. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. All of that basically means that it applies only to civil cases in federal courts. A civil case does not involve criminal matters, just disputes between private parties. It states that a trial by jury is guaranteed if the money exceeds $20. Today's cases are a much larger sum of money. The right of a trial by jury can be waived if both parties want a bench trial, which is a judge and no jury. The Seventh Amendment was introduced to Congress by James Madison in 1789. Congress took a look at what he offered and revised that to later propose to the states. The revised version was sent to the states on September 28, 1789, and on December 15, 1791, the three-quarter requirements of the states had ratified the amendment. Thomas Jefferson announced the adoption of the Seventh Amendment on March 1, 1792. The Seventh Amendment is considered one of the more straightforward amendments. For the most part, the Seventh Amendment actually wasn't incorporated to the states. Almost every state voluntarily follows it. United States v. Watson in 1812 established that the Seventh Amendment relied too much on English common law to conclude if the jury trial was compulsory in a civil lawsuit, and we didn't like that because we're Americans. Therefore, the amendment does not guarantee trial by jury in lawsuits against the government under maritime law or for patent claims, but the jury can also be waived by the consent of the parties involved. Traditionally, the right of trial by jury was a trial by jury of 12 men in the presence and under the superintendence of a judge empowered to instruct them on the law and to advise them on the facts, and, except in the exoneration of a criminal charge, to set aside their verdict if in his opinion it is against the law or the evidence. Decisions of the jury must be by unanimous verdict. You are guaranteed the right of the Seventh Amendment only in the United States courts, which includes courts of U.S. territories and the District of Columbia. The trial by jury right isn't primarily used in state courts, but when the state court is enforcing a federal right, trial by jury is used. As previously stated, a judge cannot overrule evidence found from the jury. It applies equally to a case tried before a jury in a state and to the Supreme Court. However, in cases when a claim of denial of constitutional rights is made, you can review the evidence of lower court conclusions, mostly state conclusions, which in some circumstances could conflict with the opinion of jury anatomy. Anti-Federalists opposed the Seventh Amendment. They realized that the adoption of the Bill of Rights would lessen the chance of a second constitutional convention, which is what they wanted. Anti-Federalist Richard Henry Lee argued that the bill left the most objectionable portions of the Constitution, such as federal judiciary, a branch of government, and direct taxation, and as a tax imposed on a person or property. Sales tax, value tax, and added tax are all examples of direct taxation. So basically, the Seventh Amendment is the right to a jury trial in certain civil cases. It is known to be straightforward and prohibits the courts from overruling the jury's question of fact, question of law, or point of fact. That means that a question must be answered by reference to facts, evidence, and inferences becoming of those facts. In essence, a jury can ask questions based off of evidence, and a judge cannot overturn that.